So, a brand new bill has just landed on the California governor's desk, and it could totally change how we think about social media. It's taking aim at something we all interact with every day, but probably never thought about suing, the algorithm itself. So let's get into it. Let's break down what this bill is really about, who's cheering it on, and who is, frankly, pretty terrified of it. And this is the big question, right? Can you actually sue a piece of code for harassment? Well, California Senate Bill 771 is basically trying to say, yes, you can. But, how would that even work, and what kind of domino effect would it have? Okay, so for the people who support this bill, it's a weapon they say is long overdue. Their argument is pretty simple. For years, online platforms just haven't done enough to stop hate and dangerous content from spreading like wildfire. This bill is designed to finally do something about that. So what exactly is SB 771? Well, it's a proposed law that would give people a new way to take social media companies to court. And the really critical part here isn't just about what some user posts. It's about what the platform's code decides to show everyone. It all comes down to one word: amplify. Specifically, when the algorithm is amplifying illegal harassment against people based on their race, their religion, sexual orientation, you get the idea. So that brings us to the nuts and bolts. How does this actually work legally? The bill creates something called a cause of action. That's just a fancy legal term for a valid reason to file a lawsuit. So let's walk through how that would play out. It's really a three-step process. First, you have a person who is part of a legally protected group, and they're being targeted with illegal harassment online. Second, and this is the absolute key, the platform's own algorithm has to knowingly push that nasty content out to a bigger audience. And third, if both of those things happen, the person who is targeted gets a green light to sue the company itself, not just the random user who originally posted it. Now, as you can probably imagine, this whole idea has kicked up a major storm. There's a whole coalition of tech companies and, interestingly, civil rights groups who are sounding some pretty serious alarms about what this could mean for free speech. And what's really fascinating is just how broad the criticism is. It's not just the tech lobby. You've got opponents like the Computer and Communications Industry Association, and they're worried this will just make platforms censor everything to avoid getting sued, which creates this chilling effect on any real debate. But then you also have civil rights groups like the Council on American Islamic Relations, who are afraid the law could be turned into a weapon to shut down activists. On top of all that, people are worried about the potential cost to taxpayers and a legislative process that some have said felt a little rushed and secretive. And here's a really concrete example of what they mean by weaponization. Groups like the American Arab Anti-Discrimination Committee are arguing that a law like this is ripe for abuse. They say it could be used to label sharp political opinions, in this case criticism of Israeli government policies, as illegal harassment. That could effectively silence one side of a very complex political debate. It's a powerful example of the kind of unintended consequences they're worried about. So beyond the whole free speech debate, SB 771 has another massive problem to deal with. It looks like it's on a collision course with a law that's basically been the foundation of the internet for decades. And here it is, the legal showdown in black and white. For decades, a federal law called Section 230 has been the bedrock of the modern internet. It was designed to let ideas flow freely by saying that platforms are generally not responsible for what their users post. But SB 771 walks right up to that principle and says, not so fast. It argues that platforms are responsible, not for the post itself, but for the choice to algorithmically boost it. This sets up a classic state versus federal law battle that is almost guaranteed to end up in a massive court fight. But despite all these huge legal and constitutional questions looming over it, this bill just flew through the California legislature. And that brings us to the final showdown. And when I say it moved fast, I mean lightning fast. The bill passed the Assembly on September 10th. It passed the Senate the very next day. By September 22nd, it was already on the governor's desk. And the support was just massive. The vote in the Assembly was a blowout, 51-2. Over in the Senate, it was a very solid 30-8. So even with all that vocal opposition, the lawmakers were clearly convinced. And that is where we are right now. This entire huge debate, the fight against online hate, the fears about censorship, the conflict with federal law, it all comes down to a single decision from one person. If Governor Newsom does sign it, the clock starts ticking. The law wouldn't flip on like a light switch. It would become active on January 1st, 2027. That would give platforms some time to either change their algorithms or, more likely, to get their lawyers ready for the fight ahead. You know, in the end, SB 771 really forces us to look at one of the toughest questions of our digital age. When we try to protect people from real, genuine harm online, how do we make sure we don't accidentally silence important and maybe even uncomfortable conversations? That's the tightrope this bill is trying to walk. And whether it succeeds or fails, the outcome is going to be felt far beyond California.